transfer on death deeds are a fantastic tool in estate planning. What do? They basically put a beneficiary on real property, so a beneficiary on your house. Why is this important? Well, it comes down to what is probate for. Probate is for estates that have $75,000 in probate assets or more. And what is a probate asset? It is an asset that is wholly owned outright or solely owned outright and does not have a beneficiary on it. So what do transfer on death deeds do? They take your largest asset, or one of your largest assets, your house, puts a beneficiary on it. And if you can put beneficiaries on your other assets, all of a sudden you don't have to go through probate without the pain of putting together a revocable living trust. They are a phenomenal tool for estate plans. However, a 2021 case that went up to the 8th Circuit Court of Appeals threw a wrench in this fairy tale. My name is Gregory Singleton. I'm an attorney with Signature Law, and we're here to talk estate planning. Specifically, we're talking about developments in the laws of transfer on death deeds arising from the case of David Clare Stropes and the resulting legislation. So let's look at that case, the estate of Strope. David Strope had a transfer on death deed on his house, naming his niece as a beneficiary. He put this on his house on August 11th, 2017. On August 14th, 3 days later, he died. 6 days later, Strope's ex-wife intentionally set fire to the house and burned it down. Oops. So the niece filed a claim with State Farm, as among other things that were going on, I'm sure, but the claim was denied. Why was it denied? Because the niece was not a named insured under the policy, and the named insured, David Strope, had no insurable interest in the home at the time of the fire because he was deceased. So the niece, of course, filed suit, and the district court heard summary judgment on the matter and ruled in favor of State Farm. The holding, in short, was very simple. The transfer on death deed transfers ownership, but the coverage only extended to David Stropes and not the niece. Because David Stropes was dead, there was no more coverage under insurance. And that creates a huge problem with every single transfer on death deed that's out there. Property, as soon as someone dies with their house under a transfer on death deeds, if something happens to the property before it's transferred and before the beneficiary is able to put insurance on the property, it is an uninsured asset. And that's dangerous. Think about it. When someone dies, the house sits empty. This is the prime time for someone to cause malfeasance or for something accidentally to happen. Luckily, the Minnesota State Bar Association jumped into action, and they helped pass, with their lobbying arm, Minnesota statute number section 507.072 subdivision 3 and chapter 65A. And what do these do? Essentially, they gave 30 days coverage after an individual's death. Now, it's not quite that simple. There are a couple notice requirements that are required before that coverage is extended. First is for new transfer on death deeds after August 1st, a warning needs to be put on the transfer on death deed itself before notifying the beneficiary of their need to get their own insurance. Second, there must be notice to the insurance company about the transfer on death deed and include the names and contact information of all beneficiaries and a copy of the transfer on death deed itself. Now, I am very grateful that the Minnesota State Bar Association was able to jump into action and put this Band-Aid on there. Unfortunately, it's only a Band-Aid, and there's a few problems that arise from it. A number of problems, in fact. One of the big ones is 30 days is not that much time after someone dies. Now, I know the lobbyists tried for longer. I've heard that they're tried for at least 90 days or more, but to get the thing passed in the time that they did, they compromised down to 30 days. Now, another problem is who needs to actually receive the notice. The notice in the statute says it must be given to the insurer. Now, I think that creates an ambiguity. Do you go to your insurance agency and give them the notice and trust them to give notice to the insurance company, or do you give notice to the insurance company? I've already started giving notice And I've contacted some agencies looking for the contact information for the insurance company, and the agency says you have to go through us. But I don't think that's what the law says. So we may end up seeing litigation on this in the future. Also, what happens if you change insurance companies? Do you have to give notice to your new insurance company as well, or does it travel with the policy? Any prior notice that you've given, does it travel with the policy to the new insurer? On that note, think about the insurance market. Insurance policies are bought and sold by different insurers all the time without even our notice. And that creates an ambiguity. If the insurance company sells our policy to another insurance company, do I need to give notice to that new insurance company about the transfer on death deed, or does that notice transfer or follow the property follow the insurance policy to the new insurance company? Another problem that's out there is beneficiaries need to know about the transfer on death deeds and their obligations. Yes, we put the notice on the transfer on death deed, but that is recorded with the county. That's not generally given to the beneficiaries, and the beneficiaries may not know about this 30 days. And if you look at the practice of most attorneys, they'll draft the will, they'll draft the healthcare directive, they'll draft the power of attorney, they'll draft the transfer on death deed, hand those documents over without any instructions, certainly without instructions to the beneficiaries or other fiduciaries, and all of a sudden nobody is going to know about that 30 days. And finally, this is a big one. What about existing transfer on death deeds? Ones that were executed before August 1st. Does notice need to be given to the insurance company about all of these transfer on death deeds? Because that's in the thousands, tens of thousands, possibly hundreds of thousands of transfer on death deeds that are out there for all the real property in Minnesota alone. So in some, the court found a problem, right? They identified a problem in the process that we use. The legislature made a fix, but it's only a Band-Aid. And now we're in the fallout phase where we find out exactly what the other problems are with the Band-Aid that is out there. This is generally how law works, but it's not easy and it's a little problematic. So this is more of a warning about the developments and transfer on death deeds. I hope you find this information useful. If you did and you enjoyed it, please hit that like and subscribe button. It really helps support the channel. We're doing a new video every couple weeks, generally a couple times a month. If you have questions, leave them in the comments or send me an email. Otherwise, until next time, this is Gregory Singleton with Signature Law.